Good morning, everybody, and welcome to an oral argument session of the 6th District Court of Appeal. This is being streamed live on YouTube, so please be mindful of that. Let me first introduce myself. My name is Dan Traver. I'll be presiding today. I'm joined by two of my colleagues, the Honorable Carrie Ann Wozniak, a member of this court. I'm also really pleased to introduce y'all to our Associate Judge today, who is London Kite. In her regular capacity, she is a circuit court judge for the Fourth Judicial Circuit. She sits in Duval County. We're grateful to the Chief Justice to allow us to help our court, which is in a time of need, by bringing back the pre-COVID tradition of allowing our trial court brethren to sit with us on appellate cases. And we're really pleased to have Judge Kite with us. This is case number 23-1989. It's Albert Wagner versus Sticky Holsters, Inc. et al. Mr. Davidow, you are the appellant. We typically, you represent the appellant, I should say. We typically set 5 minutes for rebuttal, but we can move that up or down if you'd like. What's your preference, sir?
If you could please, Your Honor, I would just say 8 minutes on
8
rebuttal.
minutes of rebuttal? Okay,
Yes,
no problem. You may proceed when you're ready.
thank you, Your Honor. May it please the court, and thank you, Your Honors, for the ability to appear remotely. It makes it a lot easier for us coming away from Naples. We made, at least in the appeal, 4 points. The point I want to focus on first is the striking of the expert witness at the hearing. And then I'm going to move through the issues relating to inextricably intertwined, the Roe analysis, and the non-testifying attorney. And if I turn to the first issue, and we cited to the Moore case, that's Moore Huntington Bank, and we state that the Florida appellate courts have continuously recognized that it's improper to exclude an expert on the ground that, in the opinion of the trial court, the witness is biased. And what we had here was essentially there was a collateral case. The case history is long and related. There's several cases in several courts. My firm represented Mr. Wagner in the underlying case. There was another attorney in a separate case that had, I'd say, joint representation. There were more parties. Mr. Wagner was one. There was somebody else, Mr. Murray, in a separate case. That attorney's name was Tony Lahan. And so in the underlying case where my firm's representing Mr. Wagner, we're defending against a claim for attorney's fees. And within that claim, there was another attorney who I know well and has testified, numerous times for attorney's fees for me. That attorney's name is Kerry Goggin. And so Mr. Goggin actually works in the same law firm as Mr. Lahan, who had represented Mr. Wagner in a different case. Mr. Goggin didn't represent Mr. Wagner in the different case, right? Had nothing to do with the other case. So as we go into the hearing for the purposes of the attorney's fees, there's no prior motion made. I believe I even requested, when the witness was struck, to, move for or tennis continuance or bifurcation, because
Can I interrupt you for a moment? Do you believe that you properly preserved this issue for appellate review?
The striking of the expert witness?
Yes.
Yes, Your Honor.
How so?
I believe that, well, one, we obviously objected, but two, I think we filed a motion for reconsideration if we didn't at the time. Moreover,
Isn't it an offer of proof or a
I'm sorry,
proffer required?
I didn't hear, Your Honor. I apologize.
Isn't an offer of proof or a proffer required of what the Mr. Kerry Goggins would have said?
I believe that an offer of proof or a proffer is helpful. I don't think it's fatal. And I think if I go back, I don't think it's fatal to any of the cases that we've cited. And so while I think it's helpful to the court to know that, at least in some of the cases that we've cited to bring this up, I don't think in every one of those a proffer was made for which it was reversed.
Well, how do we know that the trial court erred if we don't know what he was going to say? What if, for example, and I'm going to take something completely ridiculous that couldn't happen. What if you just said, well, Judge, I'm horribly prejudiced by this because Mr. Goggin was going to tell me all about the new puppy that he got yesterday. I mean, you would agree that that doesn't bear at all at any issue that's raised in the fee hearing. I picked a purposely ridiculous example, correct?
Correct.
All right, so if you had had Mr. Goggins say that, then there wouldn't have been any error in excluding him, correct?
I don't know that I'm fully following your
Sure. So
logic.
the purpose of a proffer for the sake of an appellate court is to know whether the trial court erred by excluding the witness. So if you'd have proffered Mr. Goggins' testimony, which it seems to me you're conceding that you didn't, and his proffered testimony would have been wholly irrelevant, could you then say that the trial court erred? The answer is no, right?
I apologize. I don't know that I'm fully following the logic behind it. I understand the purpose of the proffer, Your Honor.
Okay,
However,
so without the proffer, first off, are you acknowledging that there was no proffer here?
I don't believe there was a proffer, no.
Okay, so without a proffer, how do we know that the trial court erred? Because how do we know what Mr. Goggin would have said?
Because on the record, it was essentially stated by opposing counsel the reasons for why she struck him. So it was regardless of what he was going to say, it just was who he was. It had nothing about what was coming out of his mouth. It had to do with him individually.
Yeah, let's assume that you're right and that's error. Would it be a harmful error if he was going to testify about puppies?
Of course, this is the only witness we have. Even if the puppies had zero relevance, it's the only witness we have. We're going into a fee hearing. I think it would be judicially blind to assume that somehow the only witness at the fee hearing would potentially give testimony, as Your Honor, like you said, be ridiculous about puppies. Obviously, we've put this person together to testify to the fees. And the whole reason that he was struck, which is facially on the record, was not because of what he was going to say, but because of who he was. That's it. And that's all it was. And that was the assumed bias. And so, essentially within that hearing from this assumed bias, it's legally incorrect from the face of the record because the trial, all the cases that we reviewed, this has nothing to do with the expert that we're presenting, and even then you don't strike an expert because of the proposed bias. That goes to weight, that goes to credibility. It doesn't go to the ability to testify. And we're not seeking fees, we're defending fees. So I think in this situation, I still have 13 minutes. I think in this situation, it's clear from the face of the record. And I would agree with Your Honors that yes, a proffer in almost all respects is helpful to the appellate court. So there's a record and we understand what he's going to testify to. And then we use that for the analysis of whether it's harmful or not. But under these circumstances, this is the only witness, which we know from the record. The only reason he was excluded was from essentially a proffer from the other side that was presenting the fees, okay, saying just who he was, not what he's going to testify to, okay?
Isn't it more than helpful but required because the appellate court can't substitute its speculation on what the person had, going back to Chief Judge Traver's question, which is the appellate court can't assume. I mean, the trial court got some preview of what Goggins was going to say related to, I guess some case law. It looked to me from the transcript that maybe the trial court was confused about even what Mr. Goggins was going to testify to. So a proffer maybe not only would have been helpful to the trial court, but essential for the appellate court.
So for one, the trial court ruled expeditiously. And if I could tell you from the record, and I'll state what the trial court stated. This was the reasoning, right? This is the reasoning why the expert was stricken. You can't hire somebody essentially within your own firm as an expert. That's not an expert. That's all that came out. So then this is now the rule. This is the holding from the trial court. You can't hire somebody essentially, not even somebody within your firm, essentially within your own firm as an expert. That's not an expert. So what we're saying is that now anytime the opposing side makes it, let's call it a sandbag argument at the hearing that, this guy was related to another case, right? Not even related, works in the same firm as another attorney who worked on an unrelated case, right? So again, it had nothing to do with the testimony. It only had to do with the individual, the purpose, the expert who was there. So, and even then, there was no evidence taken on that was even accurate. It was the arguments of opposing counsel. And so I just find the let's call it burden somewhat interesting, to where you go present your witness, and now instead of having the ability to actually undo the prejudice, the prejudice is now exponentially greater.
Well, so in the trial court's final judgment for attorney's fees, paragraph 14, it indicates what you're saying, which is Mr. Goggin is not an independent expert and had no relevant testimony as to the reasonableness of the fees. There was a conjunctive there. So the exclusion may have happened based upon the court's, perceiving some type of bias or non-independence, but there was a second portion that the court based its finding on, which is no relevant testimony, and that's where my concern is.
Understood, Your Honor, and that makes a lot of sense. And I mean, what I could tell you, because I was there at that level, was that the judge walked out and said, "I don't want there to be a windfall." I mean, essentially, it was within the record, and there was no proffer taken. So that portion of that order, which the judge requested that both parties write an order, both parties wrote an order, and she essentially signed the order written by the other side. So whatever that language was that was in there, she's accepted it. That's fine. That's the order of the court. All right. It was. But there was no testimony for Mr. Goggin for which she could even suggest that there was a proffer. And so in that circumstance, I just want to present it to the court as to why there seems like there may be a gap, because that gap was essentially accepted, even though Mr. Goggin never had a chance to say anything or proffer.
What if she accepted your assertion in your opening that he was going to testify as to what was inextricably intertwined and what wasn't?
I mean, that's an assertion, and then we're taking a greater assumption, Your Honor, that, that was sufficient for her to make a finding that he had no relevant testimony. And it was a bald.
Would it be relevant for him to would it be relevant for him to testify what was legally inextricably intertwined versus what wasn't?
Oh, absolutely.
Why? Isn't that an ultimate issue of the court?
Well, no, because you have certain work. So you have to go back through and look at what work was done where. And the attorney can say, this work was done for this client and this issue. And this work and these hours were done for that client on that issue. And so I've calculated from the work that I've looked at in the receipts that this is the amount for that client and that issue, and this is the amount for that client and that issue. The other side testifying to, no, it's all one thing. Boom. You have to eat the whole sandwich. And
it
so
seemed like the trial court's conclusion was a legal one, in the sense that your client had asserted this fraudulent scheme in which Mr. Dees's involvement was critical. He's the one who facilitated this property transfer, correct?
So that within the second count under that 817034, that's where Mr. Dees was included. That was a different count from the first count for which the parties did it. So
the first count asserts that there was a fraudulent conspiracy as it related to the transfer of the property, correct?
Correct.
And then the second count said that there was a fraudulent conspiracy in relation to a transaction involving the property, correct?
Similar, not the same. There was a scheme to defraud, and for which within the scheme to defraud, the association or assistance of Mr. Dees came in. So
but in both cases, the fraud was asserted to involve the transfer of this property from Sticky Holsters to Bonch.
So correct in, let's call it, the factual underpinnings. And if Your Honor wants to get to that section, we've cited the case law, and that's what we're talking about, is the inextricably intertwined. And that is,
I'm struggling to see how it's not inextricably intertwined when the exact same transaction is alleged as fraudulent in both counts.
because the exact same transaction does not, look at the case law under what is inextricably intertwined. And I'll cite to the Angela Jacks and Co. 830 Southern Second. What is it? 169. And they say claims are inextricably intertwined when a determination of the issues in one action would necessarily be dispositive of the issues raised in the other. They aren't. They weren't. So the fact that 817034 was found not to be an independent cause of action does not resolve the claims relating to the fraudulent conveyance of all the other defendants. Didn't, cannot, did not. And so we were able to continue that transaction or that claim. And, so
Could we stop the clock, please? We'll just wait for Mr. Davidoff to get unfrozen.
I apologize, Your Honors. I'm not sure what happened. I lost the feed.
It is an imperfect medium. You may continue.
Thank you, Your Honor. So I don't know where I cut out, but I was continuing with the argument on point one with the inextricably intertwined is what Your Honor had brought me to. And I was quoting the Waverly at Las Olas Condo Association case. And they say that the party seeking fees bears the burden to allocate the issues for which the fees were awarded or show that the issues are so intertwined that allocation is infeasible. There was no allocation. There wasn't a single allocation, despite the facts within the record, that they said not 1 hour of fees was only related to the other defendants. Not done. And that's an impossibility. And the only reason that we could even look at this record and say that is the other witness couldn't even testify, which was going to come through and testify. And so we can't, with a straight face, somehow suggest that 1 minute, 1 hour wasn't even related to the other parties. It was. It was replete throughout the billing records. That's a part of this. Your Honors can see that. And so even if we were looking at this inextricably intertwined analysis to not remove 1 hour of allocation, I think is facially inaccurate on the record. And that kind of brings us into the second point we made with the Roe analysis. And it's weak.
So you are 4 minutes into your 8 minutes of rebuttal. Do you want to keep going or do you want to save anything?
I didn't know I was into the 8 minutes of rebuttal, Your Honor. I apologize.
It's that clock. Yeah.
Okay, because when I cut out, I thought it was at a different point.
No, we stopped the clock as soon as you froze.
Okay.
Do you want to hang out for the rest? Do you want to wait for the rest of it or do you want to keep going?
No. I will reserve whatever time I have left, Your Honors, and rest on my brief.
Mr. Fraser.
May it please the court, David Fraser on behalf of the appellee attorney Kevin Dees. I would like to point out on page 15 of the initial brief, the appellant casts this case as 276.85 hours of time being spent for drafting a motion to dismiss, a response brief, and a motion for attorney's fees. Even a quick review of the docket shows that Mr. Dees had to do far more work than that. This case started in 2017 when Mr. Dees was sued for drafting a deed related to a piece of property that was allegedly fraudulently transferred. The order was dismissed. The second district, a year later, affirmed the dismissal as to Kevin Dees with prejudice because it was final as to Kevin Dees. Counts remained pending as to the other parties, so it was non-final to those other parties. In response to the dismissal being affirmed by the second district, The appellant came back down, moved for leave to amend to sue Mr. Dees again. We objected to leave to amend, stating it's res judicata, it's final, you cannot sue a person again. And the court agreed. That was, it took a year to resolve that after a motion for rehearing was filed and a notice of appeal of that order denying leave to amend and the motion for reconsideration was filed to the second district. It wasn't until the stipulated dismissal of 7/21/2021, more than 5 years after being sued, was Mr. Dees terminated from this litigation. Litigation was dismissed with entitlement to attorney's fees to Mr. Dees. The appeal that was pending, another appeal related to Mr. Dees, was dismissed as part of that dismissal.
Mr. Frazier, can I interrupt you? I'd like for you to skip ahead to the hearing where the trial court, based on an objection, excluded a witness. And then there was some back and forth that is evident from the record.
Sure.
There was no ability to defend against the fees based upon the exclusion of Goggins.
So I first would like to point out what an expert's required to testify in a fee hearing, and this is set out in Roe. We have to have independent expert testimony to support
For the person that's seeking the fees, not the person defending.
Right. Well, I would submit to the court that the only way you can counter independent expert testimony would be with independent expert testimony.
Where is that required?
I think it would be logically required, rationally accepted, because if one party is required by the courts to present independent expert testimony when the central issue is reasonableness of fees, I don't think it would follow that then the other party could get biased or non-independent testimony. And
why wouldn't that just be a credibility finding by the trial court?
Well, I kind of explained in I given an example in my brief that if an orthopedic surgeon is giving testimony or is being sued for falling below the standard of care in a medical malpractice case, and the defense expert testifies, gets another board certified orthopedic surgeon to state that he met the standard of care, and the plaintiff brings in a veterinarian to testify that the orthopedic surgeon fell below the standard of care. The fact that that veterinarian happens to be doctors with the defendant, neighbors of the defendant doctor, it doesn't become an issue of bias. It becomes an issue of relevancy because that veterinarian has nothing relevant to testify. Aside from, so the central issue.
As Mr. Goggin was an attorney, right? So he can testify as to fees. I mean, I'm still not seeing why it just doesn't go to the weight of his credibility, the weight of it, as opposed to admissibility.
So I cite the Lafferty case, which talks about Roe, which requires an independent expert. And I believe Roe says that the way that we can show that a fee is reasonable, because certainly I'm going to believe my fees are reasonable. I wouldn't testify that you wouldn't expect somebody to come and testify their fees are unreasonable. So the Supreme Court requires an independent expert to come in for the moving party. I guess we can all agree to that. We disagree if there's case law for the non-moving party. But if you look at the Lafferty case cited in my brief, they point out that this is also a matter of appearance. It's a public appearance of the judiciary. What goes on in those courts of justice? And to allow the appellant's own attorney, and I say his attorney because he's a partner with appellant's attorney, and the related case, we just got done trying it 2 weeks ago in Collier County, and his partner was standing, not Mr. Goggin, but Mr. Goggin's partner was standing next to us at counsel's table. To allow him to come in and say, look, the bills that you're trying to seek from my partner's client are unreasonable. I don't think it meets the Lafferty or the goal of showing reason or showing that our judiciary takes things, it requires independence to come in when it's evaluating reasonableness of attorney's fees. So I guess I don't have any cases in my briefs that state the non-moving party has to have independence. But I would also cite that I don't see any cases where it says the non-moving party is allowed to bring a non-independent witness.
Wouldn't you concede that at least the record support is that the trial court, the exclusion was based almost solely on the lack of independence, when that is not a legal requirement for the non-moving party?
I believe, yeah, the court's
that was
decision,
the basis for the objection, and that was also the basis for exclusion.
I agree, Your Honor. The argument that I presented was you have to counter independent expert testimony with independent expert testimony. He wasn't independent, so that was the basis of the court's exclusion. But
With no
I
authority,
excuse,
with no authority.
um, I respectfully disagree that I don't think anyone has authority that says the non-moving party is required to bring independent expert testimony or is allowed not to have independent expert testimony. I was just making the what I believe to be logically following from or the fact that the way you counter independent expert testimony is with that of your own, certainly given Lafferty, which requires independent experts to keep the respect of what happens in our judicial system to the public, to say, hey, look, we have independent people coming in saying it's reasonable. If the defense can come in and say, or the non-moving party can have their own associate testify, I think it's more than an issue of weight, Your Honor. But I understand that I didn't have exact legal authority for that. But I want to circle back to an important point. If we look at the initial brief, and again, there's no proffer for this testimony, but if we look at the initial brief, and it's on page, I think it's 15, it says, had appellant been able to present his case at the fee hearing and called Mr. Goggin to the stand, appellant's expert would have cited Clappinger, in which the court held that a party seeking attorney's fees on multiple claims, one of which is a claim based upon a written contract, has an affirmative burden to demonstrate what the portion of the effort of the claim would have been. So apportionment. We don't have anything else in the initial brief that talks about what Mr. Goggin would have testified to. So if he's coming into court and he's going to testify to explain the law to the judge, look, there's no harm because they have counsel to explain the law to the judge, and the judge, this court can review legal determinations when it comes to apportionment. That draws me into my apportionment argument.
Frazier, can I ask you, isn't it error to for the trial court not to allow a proffer?
I don't think that he asked a proffer.
He asked to supplement the record. He asked for a continuance.
So
and all of that was denied.
Yeah, so with respect to the continuance, this was a fee hearing that had been continued over a year, and twice there were motions for continuance. At the record, beginning at 2472, there was an order granting a continuance, and in record 2479, there was an emergency motion for continuance. And so it was already twice continued. We're here on the third time, over a year after entitlement. And just speaking quickly to the idea that we sandbag them, if you look at the record, there's no witness and exhibit list. It wasn't transferred in the record. If you look at the docket, you can see that a witness list was filed just a week before the hearing. So this idea that we had months of notice that they were going to call Mr. Goggin is not supported by the record. But if you look at the brief, I don't believe there's any way that the appellant can show reversible error because we just don't know what Mr. Goggin was going to testify to. Certainly, there could have been a simple filing afterwards, and I've had to do it myself where I want to supplement or offer a proffer, and you file something in the record which shows Mr. Goggin would have testified to. But even in this brief, I don't see it set forth that Mr. Goggin was going to contest reasonableness. What we have is that Mr. Goggin was going to explain apportionment to the court, and he also in the brief, it talks about that Mr. Goggin was going to testify to mathematical errors. Mr. Goggin is not a math expert. If there are mathematical errors, that could have been brought to the court's attention because certainly the trial court can do math. And we don't know if those math errors are 10 cents, $10, $10,000. The court can't evaluate that. And to the extent that Mr. Goggin was going to be an expert who was going to come, and Mr. Davidow said he was going to sift through the bills and say this is a portion here and that is a portion there. Again, if it's a reasonableness hearing, is Mr. Goggin now a forensic fee analyzer who can then tell our firm who should have been billed for that or what that work was done? Again, if we look at the totality of this case, the notion that Mr. Dees was just a side player and not the central figure in this case is not supported by the record. He was a party to this case right up until dismissal, was a subject of 2 appeals and now this 3rd appeal. And with the scheme to defraud was that Mr. Dees, an attorney, helped draft a deed that then the appellant claims constituted a fraudulent transfer from a different entity. If I would have won, if I can show that it wasn't a fraudulent transfer, i.e., not trying to take away corporate assets or left the company insolvent, then I win Mr. Dees's claim. So these are absolutely connected, and Mr. Dees was the subject of this case, throughout its entirety. So I circle back to the point that I just don't know what, and I don't know how this court can evaluate what Mr. Goggin would have testified to. And I don't see that I don't even see in the initial brief that he was going to offer opinions that approximately $82,000 for 4 years of litigation was unreasonable. I would just respond, there's another point that was raised in the reply brief, which I don't think is preserved, talking about the nature of the fee award, as it being contractual versus statutory. I don't think it matters for these purposes, but just because
I guess I was just going to ask you about that. I think the whole issue of entitlement in this case is interesting. It's not really argued on appeal, except in one context, which is the request for appellate attorney's fees. And that seems to be based on a proposal for settlement.
So, and I understand that the record is kind of sparse on this. If we look at how the case was set up, there was no contractual basis for attorney's fees. It was an expired proposal for settlement, expired 57105, and the parties stipulated to dismissal approximately an hour before a Cozell sanctions hearing because it sought evidence that they knew Mr. Dees was involved in this fraudulent transfer, that it left the company insolvent. And just on the precipice of a Cozell dismissal hearing, they agreed to dismiss the case, granting entitlement to Mr. Dees. Maybe the basis, it's hard to put.
Looks like Mr. Davidaw really disagrees, and I would just kind of ask him to not do that while another attorney is arguing, because we're going to get back to him on rebuttal. So if he could just kind of hold it together a little bit better, I'd be grateful. But Mr. Fraser, it becomes important, I think, on the context of fees if you're the prevailing party, which is that I think what you're asking us to do is determine that you're entitled, and then you guys can basically have another fee hearing where the validity of the proposal for settlement and whether or not some 11th hour Cozell settlement superseded it can be addressed back then through evidence. Is that a fair statement?
That would be a fair statement, Your Honor.
Okay, thank you. I just wanted to make sure that I understood.
But certainly up to the point of dismissal, we have entitlement to that date. What happens after that, then it would get me into what Your Honor just pointed out. If I understand Your Honor's point. Hopefully I understand it correctly. With respect to point G point H, I already referenced that of the math. I also want to get to, it's point 4 of the initial brief. They cite the Neatlick case. Neatlick is an opinion, which I think it was 5 sentences, and it says that every attorney has to, or the attorney didn't testify, so they didn't get fees. Neatlick cites to, I think it's Quality Choice or Quality Holdings, in which no attorney testified at the fee hearing, and it was the general manager presented an itemization of damages and said we paid $25,000 in attorney's fees. The court reversed, saying that wasn't competent evidence to support a fee award. What wasn't briefed by the appellant here is the 6th district in the CED case. It's CED Capital Holdings, and it's 363 Southern 3rd 192. It's in my papers. The 6th district addressed this and said, no, every attorney doesn't have to. And it came up in this exact context because some districts said the attorneys have to testify. And the 6th said, no, they don't have to testify so long as there is evidence in the record to support the fee award. Here, all the firm bills were in evidence, and that, the corporate representatives testified. And if you look at the transcript, again, another error that wasn't, alleged error that wasn't preserved, because Dan Fraser is in the transcript as attending the hearing. Had the appellant got up and said, Your Honor, every attorney needs to testify, preserving the error for the trial court, then the trial court could have said, well, he's right there, we'll have him testify. But the fees are the fee records are in evidence. We have corporate representative testimony in evidence. There's the 6th DCA has expressly rejected the appellant's argument that every attorney has to testify in a fee hearing. So there is record evidence supporting the fees. I believe I've covered all my points, Your Honor. I don't know if there's any questions.
Judge Wozniak? Judge Kite?
Yeah.
All right, thank you, Mr. Fraser.
Thank
Mr.
you.
Davidaw, rebuttal? Just need you to unmute, sir.
I don't know that there was much raised that kind of requires rebuttal, and I don't think it's appropriate for me to go back through portions not raised in the first part of the argument. I mean, I think the only thing I could touch on was the second portion of the, and I'm going to mispronounce it, the Needlich case where the attorney didn't testify. That attorney had made up over 50% in this case of the billings. And I think that just kind of goes back to the lack of the record and the inability to actually present the testimony necessary from the procedural prejudice and kind of being hampered. And what I mean by that is that even if we can't call Mr. Goggin, so then there's no way to even rebut testimony at that period of time that might have come from, let's say, an opposing working attorney. So you're so hampered within the presentation of the evidence that there's really nothing else to do, and that's kind of collateral to the brief. I'm just bringing argument up to the court and providing some rebuttal as to what was stated with regard to the Needlich case and some of the case law cited by Appellee from the 6th. So, I don't know that I have significant more rebuttal. If there are questions, I'm happy to answer them. Your Honor, I think you were muted.
Judge Wozniak? Judge Kite?
No, thank you.
All right, thank you both for your presentations. We'll be in
Thank you, Your Honor.
recess.